My name is Hayrapetyan Gevorg. I'm from the Agency of Protection of Personal Data, which is acting within the Ministry of Justice of Armenia. The main purpose of creating this agency is that in 2015, the previous law of Armenia on the individual data was changed into the law of protection of personal data. We discussed a little on how the law of Russia on protecting personal data is impacting their internet, their social networks. I'm deeply convinced, and this is just interlude, that the protection of the right, this way or that way, does not depend on the form of the right. If my personal data are written on a piece of paper, they are to be protected. Doesn't matter if they are in Facebook or in internet. These were they are again to be protected, and they should be managed or handled the very same way as they are the data written on paper. Even if my personal data were written on through pentagrams or whatever, carved on stone, they would be again entitled to protection, at least in the basis of the laws that are adopted by the current civilization, is the honor and security of individuals whose data we are speaking about. So that is the right of people to protect their personal data. When they are exchanging their information in the internet, so they are protecting their personal lives. Now, in Armenia, the situation has changed since July 1, 2015, because the law on protection of personal data has changed. Actually, you could say that only the title has changed, but nevertheless, it's not that. The law on the protection of individual data did not have mechanisms on how to do it, but this new law has already mechanisms, and I'm deeply convinced that we have a very good law because it is equally relevant to information written on paper, carved in stone, and written in internet. That is a very good law and gives very generic rules. Let me go a little bit forward and tell you what is the definition of personal data in general through in our law. Even the Constitution has fixed the need for protecting the individual data. So what is personal data? Any information about the person who allows directly or indirectly, or can allow again directly or indirectly, identify the person. That is a personal data. Matvey said that the Russia's law are those personal data that allow to identify. In Armenia, it is not only allow, but it is also can allow, and directly and indirectly, and doesn't matter that there is a photo or not. Only even name and second name is considered to be personal data. Sometimes in Armenia, the name and the second name is enough to identify the person among 3 million population with full 100% of, like, for example, my boss, Shushan Doyodian, is not repeated but in my case, if you try to find Gevorg Hayrapetyan, you will see that there are a lot of people with the same name and second name. So that's why there is a difference how one personal data can allow to identify a person without any mistake. Personal data on the level of protection could be different. They could be, say, special category of personal data, biological, biometric, personal data, and this classification is very important in internet platform. Now I will stop and say the following: that for us, we made in the result of a study, when we had a survey among the citizens of Armenia, what is their attitude to their personal data, 46% were not concerned at all that their personal data are kept here or there. 60 or more percent had a very, how to say, negative attitude to the rules of handling their own personal data, because they didn't know even what does it mean. They didn't know that somebody is allowed to ask their personal data. We're not interested who's using their personal data or what. Why do I say this? Because in classification of personal data, we have such category as popular data, which are the name, second name, day of birth, day of place of birth, plus place of demise. Well, besides that, any other data which person deliberately, with his or her aware actions, has made available to people, have become popular data, and they have become popular from the widest meaning. These data are available and popular for the population, and anything can be done by these personal data. Even tricks. People sometimes give out about their lives such data in the internet, which becomes the possession of others. From the other side, whatever enters internet stays there forever. And people, when they understand, they can't erase from all possible places, even if they manage to clean their personal data in internet, but never told about his, her personal data, sexual life, and the doctor starts to develop them, to survey, analyze them, make decision, diagnostics, medication, cure, treatment, whatever, develops the medical data. But if suddenly this information about the sexual life of the person, who the person doesn't want to be available to his, her neighbor, or somehow has become popular, that is also problematic. And that can be, done in particular through internet and social networks, and the person will appear in a big trap, big and nasty trap. Now I want to put next to the social networks also the media, who are not covered by the law from the point of view of prohibitions. But as long as the media has a very big audience, they also can use their platforms for the similar functions, or vice versa. Media can disseminate information about people through the existing social networks and make them popular. That is to say, people should be very cautious in all those cases when their personal data can appear in internet. Because, for example, if I would give interview, say, 10 or 15 years ago to a newspaper, I would say, well, yes, it will be published in 300,000 copies. Tomorrow, all the paper will be used for packaging, I don't know, flowers. And the day after tomorrow, there will be no copy to give this same information for them. But whereas now, when this information appears in the social network, it stays there forever. And biometric data, which are the physical, physiological data and biological data about people. For example, your fingerprints, DNA, photography, which is used to identify a person for technical. My favorite example, that FBI takes a photo of a person and then all over the globe looks for this person and finds anywhere in the place. And so photography can be considered as a biometric. Voice of a person, even the gesticulation, your moves, how you move, how you smile, how you look, how you move your hands, whatever. I learned about a case recently that the security systems, when they are checking through retina of the eye or fingerprint, you can do it even by the style of moving, like a person is walking through a corridor, and the system recognizes recognizes how the person walks, because of the way he makes his steps. The system recognizes whether this is him or not him. So that is also personal data, and it could be used in any place where it is possible to act on behalf of the person, like in banks, in other places where only the person has access. Sometimes this is important, like for having access to limited archives or information that is very categorized. Well, I said this so as to show later that how that personal data, to what extent they are important, they could become popular if they are published. And the best example of it are the social networks. At the end, we are going to discuss several cases based on what was said. This is about what I said. Just references to the law. I don't think it is necessary right now. The law is a small law. It has only 29 articles. Whenever necessary, of course, you can. I will tell you my phone number if you need additional advice, so we don't need to cite articles from the law. I want to say that data, when they appear in the internet, at least in Armenia, it means publishing them. We do have the following. Publishing is making data available to a certain number of people or many people. Well, whoever has, well, you know how it happens. You know that you can get information from the Facebook page. This page contains exactly personal information. We are already popular, become popular. I will say a little bit more about human individuals and then go up to the state. Well, they used to say in the court cases, the judges would say that the protection right, that the defense right of a person in the court is based on the right of ownership. The person himself decides whether, to what extent his personal data are to be protected, to what extent they are to be available, to what extent they are agreeing to making them popular, and to what extent he or she wants them to be protected later. The conditions that the person from the beginning will decide, determine, define, to what extent he, she is ready or wants to share this information with others, that is determining the level of protection, be it administrative court or whatever. If he comes and asks for protection for his sexual data, whereas he or she has disseminated this information on herself or himself, that is limiting his rights of protection through court. And why is this so? Now I'm going to the next level. I will tell it about later. Sometimes our personal data are used by the state. The right does not depend on their form. Sometimes different rights are in contradiction, or sometimes they don't contradict but help each other. But sometimes the limits of one of the rights are to be squeezed a little bit, narrowed a little bit in order to widen the borders of the other right. The main principle of developing processing personal rights is the agreement of the person on that. But there is one case. We have agreed that, all of us, we have agreed that in one case it is allowed to process the data of the person without her consent. And I've opened this slide to show you that whatever is going on with the personal data is kind of processing, keeping it, registering it, writing it, using it, everything it is processing. is considered to be processing personal data. The easiest example, when personal data of individuals, taking into account even the risk of the internet popularization, for example, election lists. In the United States, a 12-year-old boy or a person who lives in Turkey is able to learn my address. Where do I live? And that is kind of in collision with state interests. And maybe part of the personal data we will have to fix as such as to be able later to others. Well, that is problematic, and there are arguments whether it is worth doing it in that scale. But sometimes, as I said, there are collisions and people are misusing it, and then states are forced to publish information about their citizens. I do not know to what extent states are participating in the internet. I am sure they have. One of my friends said that 90% of internet is not available even to anybody from the superpowers. That states can interfere, collect information, and decipher them, collect them, without asking anybody that has this data. And that is the rights of the state should be regulated somehow as well, because the state is a user of a personal data, very much as me. If I take your name and telephone number in my mobile telephone, means I'm processing your information. Same way, if a state takes personal data of anybody in order to start, for example, a criminal case against this person, then the state is bearing all the responsibilities in processing this personal data, as I do. There is no difference. Personal data that are taken with the business person, again, are making the user of the data as data processor and with the corresponding responsibilities. Same is about banks, same is about insurance agencies. Any shop, when we tell them our telephone number so as to be informed about the discounts, we are giving them our personal data, and they are becoming processors of personal data. And all of them have the same rights and the same responsibilities and have the same limitations. There are three exceptions: journalists, fiction, and purpose of art, purpose for some art or cultural literature and art. So as they would not write that somebody who is a formal official of the state, and they write about him that this official in a, say, novel or piece of art, that he's also an oligarch. And then this person comes back and says, oh, you have opened my information, you have told about me that I am an oligarch, and you... This much I wanted to say. The first site is Elections AM, that contains any information about a person, about the place of birth, the date of birth, the address, also family. It is difficult to find me in Elections AM because Gevorg Hayrapetyans are too many. If I don't tell you my patronymic, you won't find me. But it is very easy to find my boss. And it says easily finding. From the point of view of mentality, these kind of problems could be problematic because we have very searching minds. Sometimes say a boy who is in love with a girl and knows her name can use these tools in order to stalk her, actually. But, well, formally, that is also, it acquires the quality of stalking when the number is learned and somebody is using the telephone number to making midnight calls and breathing into the phone, like stalking and behaving very, very well, offensively. And that second, social networks are indicated here because as a tool, I'm convinced, as a means, are very easy tool for very quickly. You can't imagine how quickly share with the information that is given by this and person about this or other person. And then it is very difficult to erase it. In the morning, I uploaded a picture in the Facebook. Then in 5 minutes, I decided I'm going to erase it. In 5 minutes, 10 people had liked it or disliked it. So it happens so quickly that you don't have even the possibility of a second thought. In Facebook, you can say, I'm so sad, I'm so alone, and then thousands of people will immediately react saying, how come you are so sad? You are not alone. Or, you sad because you deserve it. Or you are alone because you are not good. Well, I don't want to say that this is distorting the essence of the right. But then online shops, again, I indicate it as a problem. Although in the Armenian society, the online shops are not yet considered as a problem, but it exists because there have been cases when, say, personal data have been taken, which were not necessary, like the protection of personal data and personal life. But from being legal should be also consistent, should be relevant, which means that only that much personal information is to be taken that is relevant, and it should be used in that much that is necessary, not more. For example, there was one case of an online shop where they were taking address, whereas they were not delivering. So why do they need my address if they are not delivered? So that's problematic. And besides, as a rule, the online shops today are under out of the surveillance of the state. They can be organized in a different country. They might have no organizational form. Sometimes there could be just one man or one woman empires. Somebody decides that this is a job, just he's using the online means in order to trade something, to sell something from his computer. And that is not a shop from the regular point of view. So in the context of these four dimensions, I want to speak about the right on being forgotten. They also call it virtual death, right of virtual death in French francophonic domains. It really very well defines what does mean the right of being forgetting. It means that a person has the right that something that he has or she has done bad should be forgotten. This is even true in the criminal prosecution sphere. Like, for example, a person has done something bad, has killed somebody or has done robbery, and then he has served his term, and 10 or 15 or 20 years have passed, and the courts say, now you have right to be clean. And now this example about a Spanish person named Gonzalez who 25 years ago had published something about participating in auction, saying that he has some taxation obligations. And 20 years later, he said, he applied to the court saying that every time my name and second name come forward, it says that I have tax obligations obligations, and it goes on and goes on for years and years and years. Now, for example, I want to be hired by somebody, I go to look for a job, but every time the employers deny me, they say that you are not a good citizen, you have some taxation obligations, and he sued Google, and the court forced Google to limit information about this person so as it won't be always popping up whenever you search for his name. And so these things are developing, like a porno star who has decided to use partially the right to be forgotten. For example, I don't know, let's say his name or is Poros Porosyan. And when you write Poros Porosyan, it immediately says Poros Porosyan, or say porno actress. It immediately brings up. And she said, partially, unless somebody has written Poros Porosyan, porno actress, it should not show my identity. When it is Poros Porosyan, it should not immediately bring, you are asking for porno actress Poros Porosyan, whatever. So this is going to be implemented in Armenia. In Armenia there are media outlets, media means that are publishing issues of social character. They are publishing about the mistakes of the state or giving information with legal content about human destinies, are, say, for example, giving information about, say, conditions of poverty in families, which is connected sometimes with the destinies of children. And all of this is going to be forever there. Like, for example, a child, when it was, say, 5 or 6 years old, has been reminded, or has been given, or has been shown in a video material, crying, or hungry, or in very bad condition next to a poor family, and then 10 years later the same picture will come forward, and the person who is already overcome this problem of poverty or this family violence or whatever will have very, very negative impact on the life of the already grown-up adult person. And so this is to be taken care of. And one thing, I'm going to say something. Many, many years ago in the United States, movie theaters